Joining me now, Kenneth Padowitz, a law professor at Nova Southeastern University. Professor, good to see you.
Good to see you. Thank you for having me on, Jose.
Thanks. After seeing the video, give me your analysis of how this case could play out legally and how, what does this video seem to show?
Okay. First of all, I've heard a lot of legal experts talk about this case. Most of them don't know what they're talking about Florida law. I've been practicing criminal law here for 30 years. This is not even a close case. This is a battery. There's more evidence that I've seen on television in this case than 95% of the cases of battery that I've prosecuted or defended over the last 30 years. So it's not even a close call.
Talk to me about the difference between battery and what the charge is against Lewandowski. I mean, you're talking about a different charge.
Well, I mean, basically here what we have is we have evidence of a probable cause of the standard that we're talking about, probable cause that a crime has occurred in the state of Florida. And clearly from the evidence I've seen, they meet that low standard, probable cause that a violation has occurred. Now, that's not a close call. Now, if he's going to be convicted or not at a trial, that is a close call. And if I was his defense attorney, there's clearly great defenses, and there's a very good possibility that he could be found not guilty at a trial.
So let's talk about Florida law. This is a unique state. So the fact that he essentially, in one way or another, touched her or got between Trump and her and moved her aside, however you want to describe what that is there, that in the state of Florida would be considered a crime.
Correct. Absolutely. Listen, if you had a 10-year-old daughter and some man down the street walked up to your daughter and grabbed her by the arm and pressed so hard that the blood vessels under your skin broke, that's what a bruise is. You would want that person, if you were the father of that little girl, charged with battery. Well, here, just because this person is not a child, is an adult, it's the same situation. If there's an unlawful touching and you don't need an injury, you have probable cause for a crime. And here we have lots of evidence that substantiates that crime. So it's not a close call.
In a situation where there are a lot of people and there are people moving, it is not unusual for some, touching to occur. It's the specific thing that happened here which makes it different, or no?
Okay. Well, what we're talking about now is we're going beyond whether or not there's probable cause for a crime, which there clearly is. It's not even open to argument. And whether or not there are good defenses as to whether or not there was an intentional touching, whether or not there was a crime, whether there are good defenses, defense of others, such as defending your boss, Donald Trump. Those are things that there may be very valid arguments, and there may be reasonable doubt, and there may be a not guilty from that situation. But whether or not there's a charge, whether or not there's sufficient evidence, I'm representing a woman right now who's charged with a felony, and there's a scratch. She was pregnant, and the other woman was pregnant, and there's a scratch, and that person's charged with a felony. So clearly here, there's not even open to debate as to whether or not the state attorney's office has probable cause to charge a crime here.
Kenneth Padowitz, thank you very much for being with me. I'm glad you brought this up. I appreciate your time.